Greetings everyone. I am Sia Pandita from Tasveer. If you're new to our channel, Project Tasveer is an effort to make the reporting, processing, and redressal of cybercrimes of such sensitive nature less tedious. Such crimes include revenge porn, upskirting, sexual harassment, image-based sexual harassment, cyber flashing, etc. It uses awareness to remove the hesitant nature of victims of such crimes and provides them with protective measures against it. For this, it uses podcasts, interviews, and blogs from renowned experts from the field. Today, we welcome Mr. Vagish Pandey, IP counsel at the TVS Motors Company, a practicing technology lawyer and registered patent agent. Mr. Pandey graduated from IIT Kharagpur with a Bachelor of Law in Intellectual Property Law degree. He has worked as a member editor of the Journal of Innovation, Competition and Information Law and was an associate at Khurana and Khurana as well, where he worked in patent prosecution and drafting. We are extremely grateful to have you, sir. We have a bunch of questions lined up. With your permission, shall we begin with the questions?
Thank you very much for having me here, Sia. And I'm really glad to be a part of this. I'm really glad to be able to give back to the society through the project this week. Let's please continue.
All right. So, sir, I took a look at your past experience. So, how did you decide to make the shift from manufacturing and production management to IP law specifically?
So I did my engineering from Mysore, Karnataka. I'm a mechanical engineer. And after
Mhm.
my engineering, I was working for a company, Plancy India High Performance Materials Private Limited. So it is primarily a wire drawing company that makes tungsten molybdenum wires. So while I was working for them, so there was some technology transfer that was happening from Philips because Philips were shutting down their plant at Manesar and a lot of their production was being shifted to this place. So a lot of technology transfer was happening. A lot of their machines were being brought in, you know. So that is when I was introduced to the entire concept of intellectual property and
Mhm.
how technology transfer and all these things pan out. So before that, I was not even aware. I knew that there's something called a patent, and it's something that gives a person protection. That's all about all I
Right,
knew.
right.
So until this happened, when I was exposed to that environment, I was working with the research and development team there, or more specifically the process development, where they would customize, to meet the customer's requirement, they would conduct trials and tests and these things. So that is when I found out about the law school at IIT Kharagpur, and I was like, okay, this looks pretty interesting and seems to be something that I want to do. So that is when I decided to join the IIT Kharagpur Law School, and after that, I have always worked with patents. I have been working in the field of intellectual property for the last 4.5 years now.
Mhm.
So it has been fun. It has been fun. Yes.
So, can you elaborate on your role as IP counsel at your present company and what challenges it may entail?
So currently, I am working with TVS Motor Company, and so majorly, I will not go into the specifics of what I do there, but at the very top level, what we do is when an invention comes in, we try to identify which aspects of that invention are patentable, and then we proceed to draft an application for it and then prosecute it in various jurisdictions. So everything that goes into patent application, right from when the inventor conceptual, right after the inventor conceptualizes it, well, that part I am involved in at TVS Motor Company, like from the beginning to the end. So while the patent application may get granted, may get rejected, and this may happen across various jurisdictions. Patent is a jurisdiction specific, you know, uh,
Mhm.
right. So that is primarily what I am involved in at TVS Motor Company.
And any challenges that come with your job? Uh,
Yeah, see, the biggest challenge that I have seen, I mean, not just at TVS Motor Company, but in general in the IP industry, is how less people know about the requirements for a patent application. I mean, it is really surprising because uh, many times people come to us and this is what I've thought of, this is completely new, but then it is really not patentable. And so that basic understanding, I think it is missing out. So that I believe is the biggest challenge, sensitizing people on what the bare minimum requirements are. because everything has novelty. I said, I can bring in a screw and put it on my cell phone, and that will still have novelty. But then, is it patentable? Now, this is where I think there is a lot of gap, and I think people should be a little more aware of what can be patentable, and not just from that perspective. In general, what IP essentially has, right?
Mhm.
So there is a lack of information, I believe. So that is the biggest challenge that I have faced so far in working with people. And another thing that I have faced is that most people, when they have come up with an invention, they believe
Mhm.
that, oh my god, this is a great thing, I was able to think this up. And when you tell them that, sir, no, this cannot be patented, they get
Mhm.
offended, and then it is very difficult to convince them that this is why your application cannot be filed, or this is why even if we file, it is not worth anything. You'll just be losing out a lot of money in throughout the application process and the
Yeah,
prosecution process.
definitely.
These are some of the major challenges. I think they are prevalent across the industry, not just
Mhm.
my workplace, everywhere.
All right. The next question is, how do you stay up to date with the latest developments and changes that are brought in technology law or the different regulations in across the world?
uh, See, once you are in the industry and you've been working for a while, I mean, most of your peers are people who work in more or less the same domain. So you don't
Mhm.
really have to put a conscious effort to stay aware of all these developments. So that is the first part of it, because your peers, obviously, they will be discussing these things, and you get apprised of these things when you talk to them. And the second thing is, when you go through all of these online sources that we have,
Mhm.
which provide us updates on case laws. I mean, they summarize case laws, and so they are of a lot of help. But a majority of the update comes in from my peer group, actually, from my people at the office when we discuss certain new developments. For example, the draft patent amendment rules have come in on
Yeah.
22nd of August. So before I was able to know about this from any online source or from any news channel, I found this out from my peers at the office.
Mhm.
So that is how it happens. So you will not necessarily have to put in a conscious effort after a couple of years, because that is what your
Okay.
circle is going to be. You will obviously be aware of all these developments. Yes.
So, as a student earlier, what were some sources that you found to be helpful?
So as a student, I majorly relied upon Bar and Bench and Live Lawyer, honestly speaking. So these were the sources, and specifically for intellectual property outside of India and across international jurisdictions, you have the National Patent Office websites for every country. That is
Mhm.
one source. I mean, if you're interested, you can go to these websites and check them out. And the second thing is the World Intellectual Property Organization. I mean, their
Yeah.
website is very exhaustive and it covers a lot of things. So that was a lot of help.
All right. My next question is that how do you think the legal profession itself, as we
Hmm.
as lawyers or the field, how do you think it has evolved to actually accommodate artificial intelligence?
See, I do not think that the legal profession has evolved yet. It
Mhm.
is still coming to terms with the fact that, okay, I may be able to get this done through an AI. Right. I mean, a lot of active practitioners do not make use of AI in their day-to-day use. I mean, even I do not use it.
Mhm.
Actually, as the way we have AI now, I mean, for example, Bard and ChatGPT, whatever we have today, so they always store data. Whatever data you put in, whatever question you ask, it is going to be stored. It is going to be used later for training the AI to perform better. Now, there is an inherent problem. No lawyer would ever want to first upload their data there. Like, I do not want to want someone else to know what I am working on, right? You
Mhm.
wouldn't want, unless that autonomy comes in. I think unless that autonomy of that AI system being something you completely own, and having the rights to that data, having being able to cut everyone else out from accessing your data, until that comes in, I think it will be very difficult to integrate AI effectively along with the legal profession. Not just the legal profession, even all other professions, because when research and development teams are working, they also
Mhm.
use AI tools, but these AI tools are customized and designed to suit the requirements of that team. So unless that customizability comes in, it would be very difficult to integrate AI with, whatever we have now. I mean, be it any industry. And secondly, one more thing that I think of is that the capabilities of AI as on this
Mhm.
date are very, very limited. I mean, you ask a question, it will probably, based on all the resources it has, give you an answer. But there is no certainty of how correct that answer is going to be.
Right.
Right? So that is so there is no reliability. I mean, I cannot rely. The state of AI today, those GPT models that we have today, artificial intelligence based GPT model. So I cannot rely upon them as a lawyer. I cannot rely upon them. And there was this case where a US lawyer, I'm sure you must have also come across it. He AI gave him made up cases. Right after that
Right.
fiasco, I'm
Yeah.
not very sure would want to actively use AI. But yeah, for certain things, I think AI can be used. For example, now if I want to have a brief on some legal topic that I am not
Mhm.
very conversant with, I just type it into that AI system or the GPT system that, okay, this is what I want an answer for, and it will give me a brief on it so that I'll get some understanding. So that is something that you can definitely use it for as a ready reference, maybe as a dictionary
So it's
that will
mostly,
give
for
you an answer.
convenience instead of
Yeah,
actually providing anything concrete.
yeah,
Right.
something like that. Yes.
All right. So if that's the case, what do you think would it be like to for in the intersection of technology or law and AI with civil litigation or corporate law in the future, for example? How do you think that collaboration is headed?
Uh, See, civil litigation, I have very little experience in, so I will not be able to comment there. But
All
in
right.
the IP space and in the innovation space, I may be able to tell you how it might be able to help us. So, one thing is, as a ready reference, it will be very helpful because
Mm-hmm.
a lot of cases, when the inventors have come up with something new, they find it very difficult to actually put it across or communicate it to us. So that is a difficult part to them because, see, a person who is technologically very sound, who is very sound in his fundamentals of the technology, need not necessarily be able to articulate it well enough. And that is a problem that a lot of experts face. They cannot explain the same thing very well. So this AI based systems, they may be able to help them in explaining what their invention is, what where the core of the invention is. And another application that I see is that patent searching. So we already have trademark watch softwares, AI, that
Mm-hmm.
are already functioning. You must have heard of it, trademark watch or IP watch, and there is a patent watch software. So they, based on certain keywords, they flag if a see, the in general, when a patent application is filed or a trademark application is filed,
Mm-hmm.
after a couple of months, it is always published, be it any
Right.
jurisdiction. So once it is published, these existing AI tools, what they do is based on the keywords, they will flag that, okay, this may be a relevant application. So to
Mm-hmm.
that end, AI is already being used in the IP space, IP and innovation space.
All
Right
right.
now, maybe we may be able to go a step further, but even to this day, the ability of AI to read something, understand it, and compare it with something else. I mean, there are still questions on how that will be brought about. I mean, maybe today we are not able to do it. Maybe we'll be able to do it tomorrow. And I think if that can happen, so that would be really something to supplement the efforts of all of us IP attorneys and lawyers
Mm-hmm.
across all practice areas.
All right. So have you personally ever used any AI tools and um, actually, have you used like any sort of AI technology in your professional career? And is it something that would complicate any legalities for you or not?
See, my current, I mean, where I work right now, we are forbidden from using these tools in our day-to-day
Mhm.
activities because so we are not allowed to disclose any of this information. And another thing is that one thing that I use this for is as a ready reference. That is the only
Mhm.
way I've ever used it. I've experimented with it, and the capabilities of AI are, maybe even in terms of patent drafting, it is very capable. If you were to draft a set of claims and paste
Mm-hmm.
these claims into chat gpt and tell chat gpt, please draft the set of specification, draft the specification for me, please generate a flow chart for me. So chat gpt is capable of doing it, so which I think is pretty good and very promising. In the near future, maybe except for the analysis and claim drafting part, a lot of things can be done by AI also. So
All right. What about
hello.
I?
Yeah.
Can you hear me?
Yeah, I can hear you. Please go ahead.
All right. What about IP licensing and transfer agreements? So, not moving away from AI for a bit. How do you negotiate such deals for licensing and agreements? Yeah.
So IP licensing and technology transfer are two very different things. Actually,
Mm-hmm.
IP licensing is where you essentially, get into an agreement to let someone else use your IP and whatever the terms may be. But technology transfer is actually materializing what has come out of that IP licensing agreement. Maybe I have discussed and asked, told them that I will be giving you the technology, and then making it happen is what technology transfer encompasses. So when you are going, so one instance where I have seen technology transfer being happening is individuals had to travel to a different country, meet with the experts there, understand how to operate certain machines, and then come back.
Mm-hmm.
So technology transfer, usually there are a lot of things that come under that. So primarily the two or three things that are the points of contention are how much the royalties are going to be,
Mm-hmm.
and how exactly is the transfer going to be done. In case of technology transfer agreements, how exactly will you materialize this transfer? Because not all data is always available on, in soft copies. I mean, a lot of technological knowledge, it also includes trade secrets that maybe, I mean, there are, in certain cases, there are certain equipment operators who know the nuances of operating a particular machine in a certain way. I mean, they can do it best. As I was saying, so how this technology transfer has to materialize is one of the difficult points that people have to agree upon. And the other thing is, I mean, confidentiality, which is more or less the same across every jurisdiction, that you will not disclose this. So these are some of the points that you have to be mindful of, and these are the points on which there is a lot of back and forth. That what the royalty dates will be,
Mm-hmm.
how exactly will you help us transfer, and who will bear the cost of all this technology transfer, because there is a cost involved there, right? Getting someone to travel there and bring him back here,
Mm-hmm.
ensuring that all that know-how is being transferred. So that
Right.
is one of the pain points actually, and somewhere where there is a lot of back and forth.
All right. I believe you have some experience in advising startups as well related to data privacy and IP. So, can you elaborate on that experience and if there were some common challenges that you faced?
So no, my experience with advising startups has mainly been on helping them set up shop. I mean, that is what I helped
Mm-hmm.
them to do, and all those compliances under the Data Privacy Act. So these
Mm-hmm.
startups were working with highly personalized patient data. So how they would be processing that data, and once they collect it, how is it, in what ways is it that they can collect it, and how
Right.
would they be anonymizing the data?
Mm-hmm.
So these are some of the things that I helped them with. So we identified that, uh, see, at that time India did not have have any personal data law. Right now we have the bill
Mm-hmm.
that was very recently passed. So at that time, what we decided was that yes, you can go ahead with this, but you have to be mindful of the confidentiality of this. Anonymization is something that you have to be very clear about how you're doing it. So at that time, it was not that big a challenge because we did not yet have a law. I mean, IT
Mm-hmm.
Act 2000 is all we had to worry about. That yes, we are not going to do these specific things, and we are good to go. But now, in light of the new data protection regime that we are going to have now, I think that all these things may have to be reviewed and accordingly rectified. So yes, so that's what I have
That's
done
all.
before, and I cannot go into greater detail actually.
Yeah, no,
So
I
that is.
understand. All right. In the context of patent applications, how do you actually
Mhm.
assess the novelty of an invention? How do you figure out and what factors are involved in assessing whether this invention can be patented to the specific person or not?
Yeah. So while we are working with patents specifically, novelty is not a very difficult criteria to identify. See, novelty is simply knowing that yes, what I have has something that is different from what already exists. Novelty is one of the most basic of requirements. It is an objective criteria. It should always be there, and it will always be there. Now, if I get this phone, insert a screw here, and say yes, there's a screw here that is visible, it will still be novel because have you seen a phone like that with a screw poking out of it? Have you? No,
No, no.
so that makes it novel. Yeah, so that is, so novelty is an objective criteria where anything new, any new addition, irrespective of how minor it is, if it
Mhm,
is new, it is novel. Now, the most important point that we all face a challenge in dealing with is the inventive step of it. Right, is there any inventive step to this? So across all jurisdictions, to my knowledge, these criteria are common: novelty, inventive step, and industrial applicability. Right, these are the three basic requirements for a patent application to sustain or to be
mhm,
able to go through the examination process. So there has to be a novelty, there has to be an inventive step, and it should be industrially applicable. It should not be an invention that cannot be applied commercially. So that
mhm,
is the idea. And identifying novelty, I mean, is one of the easiest of things. But inventive step is where things are different. In a lot of jurisdictions, there is no specific criteria of inventive step. Both the requirements of novelty and inventive step are clubbed together
mhm,
because their jurisprudence is not evolved at that stage where they can start identifying these two things
mhm,
as different, because the number of applications filed are so low, they don't really need it. So uh, inventive step, to identify the inventive step, there are a lot of different approaches used by different jurisdictions. So India more or less follows whatever the EU follows. So you identify the inventive step based on the technical advancement that is being brought about while solving a technical problem. That is how the inventive step is identified.
mhm,
And another approach that we use is the problem solution approach. What is the problem that is being solved? What is the solution being provided? And what is the advantage because of this particular solution, or this particular approach of solving this problem? So that
mhm.
is how we identify, yes, okay, it is based on this that I shall file and take this application forward. Right.
That actually leads me to my next question. So, what do you think are the key differences in prosecution of patents and IP technology procedures between India and other major jurisdictions like the US or Europe?
Okay, so the EU, US, EU, and India. I mean, as I told you, novelty, inventive step, and industrial applicability. More or less,
Mhm.
these requirements, they may be worded differently, but the essence is the same. See,
Okay.
these criteria, these requirements have to be there for an application to proceed.
Mhm.
Now, when we talk about the differences between India, US, and EU, India follows more or less everything that the EU follows, right?
Okay.
So India is almost not exactly, but 90% of the things are borrowed from the EU. There may be small differences in proceduralities and specifics of what happens when. That is the only difference between India and the EU. And even
Mhm.
the Indian examiners and the Indian Patent Office, they rely heavily upon the European Union's practices. And most of Indian practices have come from the practices of the EU, right? But US things are slightly different, and one of the biggest differences is in the USA. The requirement for filing a patent application is novelty, inventive step, and non-obviousness. Right?
Mm-hmm.
There is no requirement of inventive step as such in the USA, but in the European Union,
Okay.
the inventive step requirement is much stronger. The standard to which the examiners hold the patent applicant or the person who's prosecuting to determine the inventor's name, the standard is a lot more stringent in the European Union in comparison to the USA.
Okay.
So in the EU uses the problem solution approach to identify the inventive step. In the USA, it must just be not obvious to a person, right? Whatever the in the US you file an application, it should be novel, it should have industrial applicability, and it should not be obvious to an ordinary person.
Mm-hmm.
That is one. In the EU, on the other hand, it has to be novel, there has to be inventiveness, and the problem solution. It has to have a problem and there has to be a solution. You have to clearly show it to them that there is an objective technical problem that is being solved, and
Right.
this is the solution, this is the advantage that is coming out because of that solution. So the
Mm-hmm.
standard of evaluating is slightly higher in the European Union because they're very specific about certain things. In India, also, we have the concept of a person skilled in the art,
Okay.
right?
Yeah.
PSITA, right? There's
Mm-hmm.
a person skilled in the art, and there's a person uh, uh, having ordinary knowledge in the art, ordinary
Mm-hmm.
skill in the art. So these are certain concepts that we have based on which the inventive step is identified, and there are minor differences in the proceduralities of both these jurisdictions. And India also, while there are differences, but more or less everywhere the procedure, certain aspects are going to remain the same. For example, once you file an application, it will be published, and after publication, an examination, and there is the option of opposition. In India, we have a pre-grant opposition and a post-grant opposition. I believe in the USA there is no concept of a pre-grant opposition. Right, so there
Mm-hmm.
are these specific differences that we have.
All right.
And
Um.
it is because of these differences, what generally
Uh-huh.
happens is that now when an applicant applies for a patent application, he applies in various countries. So he may get a grant for an app for the same application in one country, and in another
Mhm.
country the application may be rejected.
Yeah.
So that is something that happens a lot of times.
Next question is, in addition to patents, you mentioned your experience advising on technology law as well. So, how do you
Yes.
think technology law in India has developed and improved, and how does it complement your current role right now in IP law?
See, the recent developments that we have had in the technology law space, I mean, the very recent release of the data protection bill,
Yeah.
and
Hmm.
you know, and in the very recent past, there have been certain guidelines on how influencers are going to advertise on market and these things as well. So I think we are on the right track when it comes to. I mean, we are just starting to regulate these things. The social media and the vast amount of information that is available on the internet. We have just begun to regulate this, and historically, the internet and everything on the internet has been
Hmm.
designed for convenience because the internet did not arise out of any uh, government or any a sovereign, right? The
Hmm.
internet just came to exist. It was an innovation. People started accepting it, and similarly for cryptocurrency and every such other internet based entity that we have, right? All these social media giants, social media platforms, they did not they were not conceptualized with a regulatory framework in mind. They were brought into place to make things convenient for people who want to use them.
Yeah.
So I think that is where the gap lies, because there are no fail safes that are built in to protect people, to protect data, and these specific aspects. I think that is where the biggest gap lies. So
Hmm.
privacy by design, if you've heard of that concept, is where you design systems on the internet, or you design, whenever you're designing or conceptualizing anything, you take into consideration the privacy of an individual who may use it in the near future. Right,
Right.
so that
Yeah.
is one concept that I think that needs to be built in. But even then, I think we are a very long way from reaching a point where people can feel safe on the internet and people can comfortably go about, you know, doing what they want to do without the fear of, something untoward happening. I mean, at least in the digital space. And when it comes to AI and intellectual property, when it comes to the intellectual property and innovation space, I think the theft of data is a pretty significant concern. I mean, for instance, there was a recent instance where a few Samsung R&D employees made use of ChatGPT to for something, and then there was a lot of problem internally there because all that data was very confidential and they used ChatGPT, which stores that data. Now, this very
Mm-hmm.
confidential R&D data is now available with a third party, and nobody knows what the third party can do with that data,
Mm-hmm.
right? So this gap still exists, and the technology law and the IT law, the improvements that have come in India in the very recent past, I don't think that they would still be able to address all these concerns, right? So we are still looking at technology law from the colonial lens. I mean, wherein we are trying to fit the existing laws or trying to modify them to maybe solve the problems that we are facing today. We are not looking at these problems differently. We are looking at these
Okay.
problems with the same mindset and trying to solve them. So I think that is where the biggest problem lies, that is where there needs to be a bridge, is what my understanding is. And we are still a very long way away from having a fairly safe, digital space. So that is what my opinion is on this.
Right.
Right.
Can you discuss the importance of IP enforcement in law?
Right. IP enforcement. So when we talk of IP enforcement, we talk of trademark enforcement, patent enforcement, and even copyright infringement and all these aspects. So
Mm-hmm.
IP enforcement as a blanket covers all these things. Now, AI can be used to detect. So I think the way we have patent watch softwares that I'm aware of. I'm not sure how AI can be used to. I mean, even maybe for there is cyber squatting, and there are people who you know make use of names, very deceptively similar names for websites, and they have all that information on the internet. So maybe you can use AI to identify these you know persons or these platforms where these things are happening. What I'm trying to get at is, we have already been using patent watch softwares which, based on keywords, can determine, okay, yes, this patent is of relevance to us. So similarly, when we talk about enforcement, similar technology can help us in enforcement as well, because it can try to identify that this particular technology is maybe being enforced there. But I still don't see how specifically, because enforcement requires you to identify and understand and analyze, compare the two things, and then determine that yes, it is the same thing that is being implemented here, the same thing that is being used here. Right? That is what enforcement essentially requires you to have. But
Mm-hmm.
I'm not very sure that I can see AI being able to contribute to enforce IP enforcement, except for the fact that it can maybe identify and flag that maybe your technology is being used here. But I think it is limited to that. That is what it is limited to, is what I am able to
Okay.
understand right now.
All right. And as since we're talking about AI, what do you think of what do you believe would be the future of IP law, since the amount and the volume of public access information is increasing day by day online? So, and the
Mm.
AI tools are processing the same. So, what do you think is in the future for IP law specifically?
So, future of IP law specifically, you talk
Mhm.
about. So, let me just focus on India in this context, right?
Sure.
Because if we look at the kind of improvements and kind of developments that the Indian Patent Office is coming up with, then what I can see clearly is that they're trying to make the process simpler and easier from the
Mhm.
perspective of the applicant, a person who applies for a patent. I mean, if you look at the recent rules that have been notified, earlier the time for publication was 48 months. Now they've brought it down to 31 months. You have to file for a publication within 31 months. Otherwise, your application will be abandoned.
Mhm.
Earlier, the time for responding to an examination report was 6 months. Now it has been brought down to 2 months. So all these differences, they're effectively trying to shorten the time that it takes for a person to obtain a patent grant, right? They're speeding up the process, they're improving the
Yeah.
quality of the examination reports, and they so what so that this gives a clear indication that they're trying to make the process simpler, faster, and even the government has given a lot of, you know, monetary benefits to people who file applications, because all the prosecution charges are borne by the government. So
Mhm.
the government is trying its level best to, you know, foster an innovation culture in the country. I mean, we are trying
Right.
to, and we are also supporting it, you know.
It's
I mean,
all it's
obviously, as
all very incentivizing. Yeah.
yeah, they're incentivizing it. Yes, to be
Mhm.
precise, they're incentivizing filing of patent applications. Trademarks have always been there, but it is on the patent front that the numbers have been low. So I think right now, the way AI can contribute to it, you asked me about how AI can contribute to it, right?
Yeah, I mean, you can discuss that also because the AI tools, since public access information keeps increasing, right? That
Mm-hmm.
AI tools have access to that information since it's for public access. So you have more and more data being stored by AI tools, and that do you think that would endanger the process of IP law of trademarks and patents and intellectual property rights of people specifically?
See, uh, when you put it that way, I mean,
Mm-hmm.
see, look at what a trademark protects, right? I mean, so inadvertent disclosure is the only thing that we can have to fear from this, because
Right.
I should not inadvertently end up disclosing, either be it my trademark
Mm-hmm.
or my patent or copyright. So if that fear is not there, I don't think there is any other major concern that any
Okay.
inventor or any person who's filing, because if there is
Mm-hmm.
infringement, obviously that has to be identified by the person who owns the trademark, and then if there's passing off, I mean,
Mm-hmm.
the onus is on the other party to take action. But
Right.
from your perspective, what is it that should not happen? It is inadvertent disclosure that should not happen. You should not end up disclosing something that should have been confidential. So, as I had mentioned before, until we get to that point where if I have an AI system
Mm-hmm.
and any data that I put into that AI system is going to be cut off from all third parties. Until that system comes in, I think it will be very difficult for people to start relying on such things. And one place where I can really see AI contributing to inventors and the patent landscape is helping inventors, you know, taking their concept to a stage where it is more understandable by a third party. So that is one place that I think AI can really help people with, or
All
budding
right.
inventors with.
Just one last question. What advice would you give to young students who are aiming to be inventors or entrepreneurs and they want to protect their innovations from patents or other forms of intellectual property? What advice would you give to them?
My advice to young innovators: well, try to protect everything that you can.
Mm-hmm.
And because there are a lot of instances where people have come up with very breakthrough inventions,
Uh-huh.
but there is but they think these are trivial inventions. Do not trivialize your inventions. And irrespective of how minor you think your invention is, just reach
Mm-hmm.
out to someone or maybe go on the internet and try to look if this is worthy of being protected. I mean, I think the resources that we have at our disposal today, even with ChatGPT and Bard, you
Mm-hmm.
just type in, is this patentable? What is the status? Even that will give you a sufficient enough background based on which you can conclude whether you should proceed with this or not.
Mm-hmm.
Right. My so advice would be to you do your best and you try to protect everything. Everything you do should ideally be protected in some way or the other, right? When I say everything you do, every innovation or every improvement in already existing techniques or already existing technology or your know-how or your in your subject of expertise, that would be,
Protect everything, basically.
yeah, protect as much as possible, or
Yeah.
at least make an effort to. Unless you make an
Mhm.
effort to identify whether this is protectable, you will not even know.
Yeah,
And in a
definitely.
lot of cases, it is not advisable to protect also. I mean, there are such instances also where it is better to not tell anyone, right? But
Got it.
what I'm saying is make that effort to identify
Hmm.
that what category does this fall in? Should I protect this? Should I not protect this? Should I disclose this? Should I not disclose this? Right, that I think that is going to make all the difference, and it will take us further to bring in innovation as a part of our culture. I mean, as a part of our day-to-day life, not culture, I'm sorry, as a part of our day-to-day, it'll be ingrained in us eventually. So that is what I think,
All right.
right?
Thank you so much, sir. That was all with the questions. It was
Okay.
great to discuss this with you. Really.